Hi, good evening everyone, or good morning or afternoon for those who are watching this on a different time. Welcome to week 3 of our lecture series on the law on partnership. And for this week, we will only have two videos. The first one being this one on dissolution and liquidation, and the second video on limited partnership. So, I will try to keep this as short as I can. Kasi I've looked at other videos and my goodness, they took 3 hours. And I was hoping to make it shorter. Okay. So what is dissolution? Dissolution is defined under Article 1828 as the change in relation of the partners caused by any partner ceasing to be associated in carrying on the business, as distinguished from winding it up. As you can see, so I put jiffies now, just to emphasize the point. So what is the purpose of a dissolution? It will affect only future obligations of the business. It does not abrogate contracts. Therefore, contracts that were entered into, whether they were already partially executed or not, must be completed, even if there's already a declaration of dissolution. So, a partnership is still existing. So, no new partnership business will be undertaken except liquidation. So, upon dissolution, again, no new business will be undertaken except liquidation. Now, because of the definition stated, a dissolution is not the same as winding up, and it's not the same as termination either. In fact, that's the sequence. There must be a dissolution, then a winding up before a partnership is considered terminated. So, what is winding up? A winding up is the process of settling the business after dissolution. And that's already discussed also under Article 1829. Without meaning to belabor the point, a dissolution is not the same as extinguishment, it's not the same as cessation, it's not the same as winding up, and neither is it the same as a suspension. So what are the kinds of dissolution? Dissolution can be broken down into three kinds: an automatic dissolution under 1830, a judicial dissolution under 1831, and a dissolution by change in membership under 1840. Now, this list is exclusive. Any other ground is not a legal cause for dissolution. This simply means that any ground outside the list will definitely make the party liable for damages. In fact, there are some instances stated here in the articles in this slide that will already make a partner guilty for damages in some instances. No? So, it should not mean that any cause for dissolution outside these stated is not allowed. Again, as I have said countless times, there is no such thing as an indissoluble partnership. Now, for those of you who do not know her, this is the Rogue from X-Men. The reason why I put her is because I feel that 1838 is a rogue provision. Why do I call this a rogue provision? Because De Leon, for those of you who are reading his book, did not include this in his enumeration. However, if you read that provision, which we will discuss later, you will see that the result of 1838 is a dissolution. Technically, it's part of judicial dissolution because the innocent partner still needs to go to court to have the partnership contract annulled. Okay, so I will discuss that later. What are the causes of dissolution? The causes can either be in violation of the partnership agreement or a dissolution without violating the agreement. Say, what is a dissolution without violating the agreement? If it's one at will and a partner just wants to end it at any time in good faith, or the partnership is one for a specified term or particular undertaking and that term has already arrived, or the undertaking has already been fulfilled. Another cause is a voluntary versus an involuntary dissolution, and a judicial versus an extrajudicial dissolution. For those reading De Leon, you might be wondering, why is there a fourth one, an automatic versus a judicial dissolution? In my opinion, it's more appropriately a kind of dissolution, which is the previous slide. No? Okay, so let's now continue with the kinds of dissolution. An automatic dissolution is one covered under Article 1830, except number 8. Number 8 is a judicial dissolution. No? So, an automatic dissolution contemplates well, technically 10 instances. Kasi there are 7 items here and 4 sub-items under number 1. So the first type of automatic dissolution is a dissolution without violating the partnership agreement. And that contemplates further 4 instances. As I've mentioned, 1, if the term has already arrived or the undertaking has already been completed, then the partnership is automatically dissolved. Number 2, by the express will of any partner who must act in good faith if it's a partnership at will, because there's no term or no particular undertaking specified. Letter C, by the express will of all partners. Please note, all partners who have not assigned their interests or suffered them to be charged for their separate debts, either before or after the termination of any specified term or particular undertaking. So letter C contemplates a partnership for a fixed term or a particular undertaking. What is required here, note, is unanimous, not majority, agreement by the partners. Otherwise, if it's just a majority, there is a breach of contract. So may violation of agreement yon. Now, when you talk about all partners, please note that they only refer to those who have not assigned their interests. So those who have assigned their interests are not counted. Okay. And letter D, by the expulsion of any partner from the business bona fide in accordance with such a power conferred by the agreement between the partners. Bona fide means in good faith, if you look at the legal dictionary, as opposed to a normal English dictionary which has bona fide. No? So, there is no violation of agreement if a partner is expelled from the business in accordance with the power given to the others under the agreement. Okay, number 2, dissolution is caused by the through a contravention of the agreement or a violation of the agreement where the circumstances do not permit a dissolution under any provision of the article by express will of any partner at any time. So this is actually a catch-all provision. So here, what is required in order for dissolution to take effect is notice. Because here, it contemplates the will of any partner. When you say will, it's an intent. It's an internal thing. You cannot see it, as opposed to the death of a partner, insolvency of a partner. There is physical evidence for that. Here, since you cannot tell if a partner does not want to continue with the partnership, then the partner who wants out needs to communicate it through notice. Okay, number 3, there is an automatic dissolution when by any event which makes it unlawful. When you say any event which makes it unlawful, usually that means there is a law that later decrees that particular business as illegal. So here, what is unlawful is either the business of the partnership or the members. Now, be careful. If the business, the object of the business is illegal from the beginning, there is no partnership to speak of, and we've already discussed that in the very first video of week 1. This only contemplates a situation where at the time of entering into a contract of partnership, the object or the purpose was legal, and then it later on became illegal. The example of De Leon would be when there is a war between countries where the partners are respectively citizens thereof. So because of war, then the partners are technically at war with each other, being citizens of the fighting country. So the business can be declared illegal. Now, what is an event where it would be unlawful for the members to carry on a partnership? In a law firm, a partner who is later appointed judge cannot anymore practice privately. That's under the law. A judge must only be exclusively in government practice. Number 4, when a specific thing which a partner had promised to contribute to the partnership perishes before delivery. In any case, by the loss of a thing, also when the partner who contributed something reserved ownership of the property. That's the same also. If the property which the ownership is still with the partner that perishes, then the partnership is dissolved. Okay. The partnership shall not be dissolved by the loss of the thing when it occurs after the partnership has acquired ownership thereof. So, number 4 means that this is actually in harmony with our discussion in our first video of week 2. If you remember what I mentioned before, a partnership exists even if the partners have not yet given their promised contribution. So, as long as they agreed to contribute money, property, or industry, for the to engage in a business, to divide the profits among themselves, then there's a partnership already. Excuse me, sorry. So, even if they have not agreed, even if they have not actually given or delivered the property they promised to deliver, then there's still a partnership. In that case, if it's a specific thing, and before delivering it, it becomes lost, then the defaulting partner, failed to fulfill his or her obligation, so the partnership is dissolved. This is different from a situation where a partner promised to contribute a generic thing. What's a generic thing? I promise to contribute money, or I promise to contribute paper without particularly stating what type, diba? Or I promise to contribute the location of the business without specifying that I promise to contribute a lot in EDSA, Corner, Ortigas. So that's specific. But if it says here, I just promise to contribute our venue, then that can be considered generic. If what the partner promised to contribute is a generic thing, and he or she fails to deliver it, then there is no dissolution. Why? Because if you remember Article 1786, Paragraph 1 and 1788, a partner becomes a debtor for whatever he or she promised to contribute and shall be liable for eviction or damages with interest. So, again, going back to number 4, the default in the partner's obligation to deliver also happens when the partner allows only the use or enjoyment of the property. Because if the partner reserves ownership, o sige, I'll let you use, say for example, I promise to contribute the use of my house. If I lose the house, then I cannot contribute anymore the use. So obviously, there will be a dissolution. So here, just so that I will make it clear, we're talking about a specific property which perishes before delivery. If after the delivery, it is dissolved, it is the partnership that will shoulder for the loss. What happens then? If that happens, then the partners can contribute additional capital to save the venture. If you remember, 1791, the contribution of additional capital is required if the majority of the partners decide that it's necessary to save the venture. For example, A, B, and C, A promised to deliver a lot located in 1 EDSA, diba? 1 EDSA, Quezon City, and A delivered it. So now the ownership is with the partnership. Then a week later, that lot, 1 EDSA, burns to the ground. Say there's already a building there that's already contributed. The partners, since the partnership will absorb the loss, now the partners will have to discuss, is it so vital that we need to bring in more capital, or can we continue without it? Diba? So that's what happens after. Okay. Number 5, there's an automatic dissolution by the death of any partner. However, a partnership agreement may provide that the death, withdrawal, or admission of a partner will not affect a dissolution. So, in case of such an agreement, the estate of the deceased is not liable for obligations contracted after dissolution beyond the extent of the deceased partner's capital or interest. So, I just want to note that because that's part of the books that I've been reading. Yeah. So, note, as we will discuss later when we go to Article 1833, the dissolution caused by a partner's death can still make the deceased partner's share liable for another partner's act after dissolution, meaning even if that partner died, if the acting partner had no knowledge or notice that the other partner died already. So another possible effect of dissolution by death is if the deceased partner's representative allows the continuation of the business, which is strictly speaking the formation of a new business, no? And there is no assignment of the deceased partner's right in partnership property. Then the creditors of the dissolved partnership shall also be creditors of the partnership continuing the business. But this is effect. I hope I'm not confusing you. I'm just being a little bit advanced here. Don't worry. We will go back to that later. Okay, number 6, there is an automatic dissolution by the insolvency of any partner or the insolvency of the partnership. If it is the partner that is insolvent, the effect kasi would be to subject the insolvent partner under 1814, if you remember our charging order. So it would make it impossible for that insolvent partner to be liable pro rata if the partnership assets are insufficient to cover its liabilities. That's why there is an automatic dissolution. Because the essence of a partnership is that if, aside from what was stated under its definition, no, 1767, the essence of a partnership is that if the partnership's assets are insufficient, then the creditors can run after the personal assets of the partner. So if one is insolvent, syempre, there's nothing to run after anymore as regards that insolvent partner. I hope I'm making sense. Okay. Number 7 is by the civil interdiction of any partner. So, the reason why there is a dissolution here because the partner naman cannot validly give consent or the capacity to give consent is limited. That's why the dissolution is already automatic. Kasi again, as I mentioned, diba, partners are agents of the partnership. So each can act on behalf of the partnership. How can you act if you are already declared under civil interdiction? Number 8, by decree of the court. So it's not an automatic dissolution. It's just a transition to Article 1831. Judicial dissolution. So, why is there a jiffy here that says, yeah, that's just like your opinion, man? It's because the reason why there is a need for court intervention, because the grounds stated here are subject to dispute or difference of opinion. Kaya nga, that's why there's this really cute jiffy. And please forgive me because at my age, I'm already super natutuwa when I find a jiffy that I feel is appropriate for the topic. So, under Article 1831, on application by or for a partner, the court shall issue a decree of dissolution whenever, number 1, a partner has been declared insane in any judicial proceeding or is shown in that judicial proceeding to be of unsound mind. Number 2, a partner becomes in any other way incapable of performing his part of the partnership contract. So here in number 2, incapacity must relate to the partner's inability to perform his or her duties as a partner. Number 3, a partner has been guilty of such conduct as tends to affect prejudicially the carrying on of the business. Number 4, a partner willfully or persistently commits a breach of the partnership agreement. It must be willful and persistent, or otherwise conducts himself in matters relating to the partnership business that is not reasonably practicable to carry on the business in partnership with him. So number 3 and number 4 refer to a partner's misconduct. So De Leon gives an example, inveterate drunkenness. Inveterate meaning a habit that is unlikely to change or ingrained into someone. And then for another book that I'm reading, he adds great extravagance, masyadong magastos. The partner keeps spending that the partnership will eventually be at a loss. Or there's also another example, unwarrantable negligence. So here, when you say misconduct, there is gross neglect or breach of duty. Normally, courts are very cautious about dissolving partnerships based on misconduct because it's difficult to draw a line indicating that draw a line between what is behavior that would authorize a dissolution and what is just simple misconduct. Number 5, the court will decree a dissolution if the business of the partnership can only be carried on at a loss. Only. Not if it's at a loss for 1 year, because it's possible that the partnership will bounce back. And number 5, when you say loss, let me just give an example. This is a 1916 case. So a partnership was formed in 1901, can you imagine? For a rice cleaning business in Gaupan. This is Lichauco versus Lichauco for those who are reading De Leon. So the partnership was for a rice cleaning business and for the purchase and sale of palay and rice. So the partners contributed 100,000 and the defendant in that case contributed 60% or 60,000 in the form of machinery. So that business was profitable at first. From 1901, it was profitable until 1904. And then, in May 1904, the managing partner, found that it was not anymore profitable. So that managing partner decided to discontinue the business. What he did was he dismantled the machinery and offered it for sale. At that time, after over and above the partnership liabilities, the partnership still had an excess of 20,000 cash. So it was at a profit. But he didn't tell his partners about the discontinuance or the sale until 1906 to 1907, or 2 to 3 years after. And by then, he claimed that the partnership only had 634 pesos. That's a lot of money if you're talking about losing around 19,363.36. Am I right? So that's a lot already. So now the parties went to court. They wanted to dissolve the partnership because they said the articles of partnership required a 2/3 vote. So the Supreme Court actually struck down that provision, the 2/3 requirement. The Supreme Court eventually dissolved the partnership under number 6, other circumstances that render a dissolution equitable. Why? Because the Supreme Court said the agreement denied the right of the partners to effect a dissolution through judicial intervention, because the contract is the law between the parties. So the courts cannot actually go against the law of the parties, no? So again, what the Supreme Court did, they made an equitable decision, number 6. They said it would be absurd and unreasonable to hold that such an association could never be dissolved and liquidated without the 2/3 consent of the partners. Especially in this case, that other circumstance is the partnership already lost all its capital, and then it became bankrupt, and then the manager abandoned the business. So that was the other circumstance that was contemplated. So there is also fraud in the management of the business. That can be another circumstance, or refusal without justifiable cause to render an accounting. So the partners now can run to the court if they want to and ask for a dissolution decree under number 6. Other dissolution can be a lack of confidence. In any case, all the instances mentioned must be of a serious or permanent character that would prevent the profitable continuance of partnership business. So it must be serious or permanent. Excuse me. Take note, although I'm not sure it's really important or needed, but you might want to know, courts will normally not dissolve a going and prosperous partnership merely because of friction between partners, especially big partnerships where there are factions. So usually in partnerships like that faction A is fighting with faction B. For those who want to go to law school, there is a very big firm called the firm which fought. They had a very big building in Taguig, to the point that because of their fighting, there was a faction which occupied a particular floor of that building, and another faction which occupied another portion. Nagsiraan po ng gamit. They started destroying things, from what I heard from the grapevine. So in that case, usually, well, technically you can dissolve if it really reached a point that, business cannot be continued. Syempre, delectus personae, there's no such thing as indissoluble partnership. But Courts will not normally dissolve it if it's just to interfere with knowing who is more at fault. So, it must be serious. So, in that case, yung sa away ng law firm, it was really serious. In fact, it was going around the legal community. And we were already keeping in touch with our friends who were associates in the different firms. Well, within those two factions. Okay. Now, paragraph 2. A judicial dissolution can also be sought on application of the purchaser of a partner's interest under Article 1813 or 1814. If you remember, 1813 talks about when an instance where a partner conveys his interest to someone else, either through sale or through assignment. And 1814 is the charging order where a judgment creditor, meaning a creditor declared by as a creditor by a court, yan, who seeks a charging order. So there, in this case, they also have the right to seek for a judicial dissolution, not just the partners themselves. And it's in two instances. One, after the termination of a specified term, and two, at any time if the partnership is at will. So when you say partnership at will, take note our previous discussion where we said where there is a conversion. I think, if I'm not mistaken, under Article 1817, doesn't matter, you don't need to memorize articles. Remember, where a partnership is one for a specified term, and the parties conduct themselves in a way that they are doing the they are continuing the business by their conduct, then the business is converted from a partnership for a specified undertaking to a partnership at will. Yeah. So, for example, in a case where A, B, and C are partners in a partnership for the construction and sale of a building, and A assigned or sold his share, in the business to X. X cannot apply for the dissolution of the partnership until the building has been sold, because that is the purpose of the business. It would be a different situation if the building was sold and the partners decided to continue with the business. Say they converted it into a general construction business. So, because of that conversion, the partnership becomes at will. X would then be entitled to seek judicial dissolution of the partnership at any time, starting the point where the partnership becomes a partnership at will. Okay. Now, let's go to the rogue provision. Dissolution by rescission. So again, this is what I call the rogue provision. If you remember in your law on obligations, a contract is voidable or annullable under Article 1390, number 2, when consent is vitiated by fraud, meaning the consent was not based on on complete information, no? So here in Oblicon, if you remember, if a contract is annulled based on a vitiated consent, then the partner is entitled to restitution. So that's why I put an asterisk here on dissolution by rescission, because rescission, if you're going to be strict about it, has a different meaning and can be availed of under different circumstances. That's why I say dissolution by annulment, kasi you need to have the contract annulled based on vitiated consent. Okay, so under Article 1838, so if you want, you can write dissolution by rescission, because that's what the law states, although I feel that it's really the wrong term. So where a partnership contract is rescinded on the ground of fraud or misrepresentation of one of the parties thereto, the party entitled to rescind is, without prejudice to any other right, entitled to 1. A lien or a right of retention on the surplus of the partnership property. And then 2, the innocent partner, if I may call him or her that for purposes of this discussion, the innocent partner also has the right to stand in the place of creditors of the partnership for any payments made by him in respect of the partnership property. Meaning, if a partner gives money aside from contribution, outside of his contribution, then if, for example, there's a partnership A and B, and A was tricked by B, may fraud on the part of B. So the business continued, meaning the business is valid. If you remember your law on contracts, a voidable contract is valid until declared void by the court. So they enter into contracts, they get into the partnership, acquires liabilities. If later on A realize, oh wow, I was tricked into it, so I want to have the partnership contract annulled. And in the process, A paid off the liabilities of the partnership, then A will stand as the creditor of the partnership. And number 3, the innocent partner can be indemnified, by the person guilty of the fraud against all debts and liabilities of the partnership. So, number 2 discusses the right of subrogation for those who plan to take up law later on. So, the right of subrogation is when you take the place of the creditor. In this case, the innocent partner takes the place of the partnership creditors because the innocent partner already paid. So, ngayon, it is, may utang na yung partnership kay A. 1838 contemplates material deceit and not just exaggerations by one partner. So, for example, in a partnership between A and B, if B said, oh, why don't you invest 100,000? We'll buy and sell masks with the COVID, where I'm sure we're gonna earn millions. Ganyan. So, that's just an exaggeration. So that A might not be able to get a judicial dissolution based on 1838. But, if for example, for those of you who know, the scams, networking scams, not all networking companies are scams, ha. I'm just saying, if you know yung mga pyramiding there, B approaches A and says, A, if you invest 100,000 with me next month, the 100,000 will become 200,000. So, yan, that's deceit. They'll say, oh, what business will we do? Simple, we'll just recruit. And if you recruit people, each new recruit must pay 100,000. So if you get to recruit one, your 100,000 will. If you recruit two, you'll get 200,000. Obviously, kasi you got the investment of the recruits, no. So that's deceit. Okay, so now let's talk about the effect of dissolution. So what happens now? The general rule is that every partner is considered an agent of the partnership with authority to bind the partnership with respect to its business transactions. Since dissolution stops the partnership as a going concern, the partner's power of representation also ceases except to wind up affairs, including finishing transactions that have already begun. What this simply means is that a partner cannot undertake new business, and I've already discussed this earlier. So, under Article 1832, except as far as may be necessary to wind up partnership affairs or to complete transactions begun, then dissolution terminates all authority of any partner to act for the partnership. One, with respect to the partners, it is terminated, meaning between the partners, any partner's authority is terminated automatically if the dissolution is not caused by the act, insolvency, or death of a partner. However, if the dissolution is caused by an act, insolvency, or death of a partner, then a partner's authority is terminated only if it falls under Article 1833, and I'll discuss that later. Now, with respect to third persons, a partner's authority is terminated only if it satisfies the requirements under 1834. Okay, so before I move on to the next, no, a partner may, after dissolution, assign to a creditor firm assets without the consent of other partner because it can be considered a transaction to wind up partnership affairs when you assign to a creditor firm its assets. Usually kasi when that happens is usually for discounting purposes. As accountants, I'm sure you'd know, when you sell assets for a lower amount for purposes of expediency, right? Because you want the cash already. A partner cannot bind his co-partners or the partnership by borrowing money unless it was explicitly stated that that person has authority to, despite a dissolution. Because borrowing, even if it is to meet a pre-existing obligation, meaning an obligation entered into before dissolution, is generally considered a new contract. Okay? So, again, I will repeat because people might be confused, as I was confused before when I was studying this provision. How do we understand 1832? A partner immediately loses authority to act for the partnership, except to wind up, if the cause of the dissolution is not by the act, insolvency, or death of a partner. Number 2, a partner does not immediately lose authority to act for the partnership if the dissolution is by the act, death, or insolvency of a partner. In such a case, 1833 will apply. It's as if there is no dissolution unless the acting partner had knowledge of the dissolution caused by the death, by an act or death or insolvency of a partner. Okay. For 1833 to apply, meaning the liability of the partner to each other, the contract of the partner must be binding on the partnership. Although the law does not define what constitutes, let me read first. 1833, where the dissolution is caused by the act, death, or insolvency of a partner, each partner is liable to his co-partners for his share of any liability created by any partner acting for the partnership, as if the partnership has not been dissolved, unless, meaning these two instances will not make a partner liable for another partner's acts. 1. If the dissolution is caused by an act of a partner, the partner acting had knowledge of the dissolution, meaning had knowledge of that act which caused the dissolution. And number 2, the partner will not be liable for an acting partner's acts if the dissolution caused by the death or insolvency, the acting partner had knowledge or notice that that partner died or became insolvent. So, take note that there is a difference. A partner will not be liable if the acting partner had knowledge of the act causing the dissolution, or if the acting partner had knowledge or notice of the death or insolvency of another partner. So, although the law does not define what constitutes knowledge or notice, several books use the definition under the U.S. Uniform Partnership Act, especially since the new provisions, meaning the ones in the new civil code, were taken from the UPA, the Uniform Partnership Act. So, in that case, it's very easy. Knowledge is not only actual knowledge but also contemplates instances when a partner knows of other facts or circumstances that would show bad faith. And number 2, notice of a fact is when someone states it, someone notifies you or delivers such fact through mail or other means of communication. So, to summarize, again, and so that it will become easier rather than just memorizing 1833, a partner's authority to enter into contracts is terminated if 1. The cause of the dissolution is not the act, insolvency, or death. Then upon the occurrence of the cause, the partner has no more authority. Number 2, if the dissolution is caused by the act of a partner, a partner loses authority, had knowledge of the act. So upon knowing of the act causing the dissolution, then he loses his powers. And number 3, if the dissolution is caused by insolvency or death, a partner loses his or her powers or authority upon knowledge or notice of the death or insolvency. That's why I put Dragon Ball yung power ni, forgot his name. Okay. Now, if you remember our discussion under 1832, it also talks about the authority of a partner to act for a partnership with respect to third persons. When is the authority of a partner considered terminated insofar as third persons are concerned? It says here, you must comply with 1834. So, what is 1834? It's a bit long. So, it talks about the liability of the partnership to other third persons, no? So, Article 1834 is divided into 3 paragraphs. So, this is the first paragraph. I placed here second paragraph because it's confusing eh. The codal provision does not state which is the second paragraph and which is the third. And this is the third paragraph. Yeah. So, paragraphs 1 and 2 binds the partnership. Yan, here. I'll put na lang a line. There. This, excuse me, sorry. Anything above the yellow line binds the partnership, and anything below the yellow line does not bind the partnership. Therefore, there are 4 instances, 1, 2, 3, and 4. There are 4 instances which will bind the partnership, while there are 3 instances, plus another one I will discuss later, which do not bind the partnership. So, the 4th instance, which is not stated here, is where a third person already has knowledge of the firm's dissolution. It will not bind the partnership because that way, that third person is in bad faith. You already knew that the partnership is dissolved and yet you already entered into another contract with any partner. That's unfair. Because of 1834, the partnership is bound even if the acting partner's authority is already deemed terminated under the previous articles that we mentioned. In that case, in cases like this, meaning a partner's authority is already terminated, but the partnership is still liable because there is compliance with 1834. The innocent partner who will be made to pay later on can always recover from the acting partner. Alright. So let's get into the nitty-gritty of 1834. After dissolution, a partner can bind the partnership except as provided in the 3rd paragraph. Okay. So what are the instances where the partnership is bound? Number 1, by any act appropriate for winding up the partnership affairs or for completing transactions unfinished. That's self-explanatory. Number 2, a partner can bind the partnership by any transaction which would bind the partnership if dissolution had not taken place, provided the other party to the transaction A had extended credit to the partnership prior to dissolution and had no knowledge or notice of the dissolution, or though he had not so extended credit, had nevertheless known of the partnership prior to the dissolution, and having no knowledge or notice of dissolution, the fact of dissolution had not been advertised in a newspaper of general circulation in the place or in each place if more than one at which the partnership business was regularly carried on. Okay, phew. I'm sure you're confused already. Let me dissect number 2 for you. So, in number 2, this talks about a normal transaction, meaning a transaction that the partnership enters into because of the running the business. So, these transactions, they continue because normally the people that you are transacting with don't know that the partnership is already dissolved. Remember, there's always an assumption that an entity is a going concern. Remember your accounting policies. So, in that case, A and B contemplates 2 types of people. In A, you're talking about a prior dealer. Yan. people who extended credit to the partnership. Extend credit ha, not purchased from the partnership. Someone who is a prior dealer, meaning someone who extended credit to the partnership prior to the dissolution, who had no knowledge or no notice of the dissolution, will bind the partnership. Any credit extended prior to the dissolution, as long as that dealer had no knowledge or notice of the dissolution. So notice must be actual. There is no duty for the dealer to inquire into the status of the partnership, even though that partner had the means to know. Otherwise, it would be difficult because every transaction, that prior dealer has to check, oh, is everyone alive? Everyone is solvent? It's tedious. It would slow transactions down. Especially for prior dealers that the partnership normally transacts with. So note, when you say extend credit, it does not talk about people dealing with a firm on a cash basis. You're not a prior dealer if you deal with them on a cash basis. One who purchases goods from the partnership is not a prior dealer, meaning suke. One who buys from the partnership, a regular customer, that's not a prior dealer. We're talking about an entity that previously extended credit. So I just want to emphasize that. And number 2, everyone else who is not a prior dealer. So if for a third person, any third person, as long as they knew that this partnership existed prior to the dissolution, they are any transaction entered with these people are binding as long as they have no knowledge, no notice of the dissolution, and the fact of dissolution was not advertised in a newspaper of general circulation. What does it mean? For those who plan to study law later on, advertisement in a newspaper of general circulation is constructive notice, meaning it's not personal notice. I did not give you a piece of paper saying, oh, we are dissolved, but it is considered as if the whole world was notified. Excuse me. So take note, newspaper of general circulation. You might ask, how about if I emailed I posted on Facebook and it's public? Nope. The law is strict, so we will follow what's stated there. At the time that the law was made, of course, they did not even contemplate internet. Wala pa atang internet then. Constructive notice is sufficient for those who do not fall under A, those who are not prior dealers. I'll give an example. This is an example by De Leon. T purchased goods from A, B, and C company. After T purchased goods, A, B, and C company was dissolved and it was advertised. After it was advertised, T extended credit. The question was, is the partnership liable? The answer is no, because T is not a prior dealer, because he only extended credit here after the dissolution. So, at the time that ABC and company was dissolved, notice through the advertisement in the newspaper operates as constructive notice to T, because T is not a prior dealer. All right. So, let's continue. Now, paragraph 2, the liability of a partner under first paragraph number 2 here, by any transaction, if it's meaning not a transaction for winding up, shall be satisfied out of partnership assets alone when such partner had been prior to the dissolution, number 1, unknown as a partner to the person with whom the contract is made, and 2, so far unknown and inactive in partnership affairs that the business reputation of the partnership could not be said to have been in any degree due to his connection with it. Alright, what does this mean? If a third person enters into a contract with an unknown partner or with a partner who is unknown and inactive, then the partnership is bound. But there's a qualification. the liability of the partnership is only up to the extent of the partnership assets alone. What does that mean? If someone, say A, if someone, say X, entered into a contract with ABC and company partnership, and the one that X is transacting with is D. X didn't know, it was an unknown partner, he thought employee lang si D, he thought D was just a supervisor, diba? Then, the partnership is bound. Except that, if the liability to X is greater than the partnership assets, X now cannot run after the personal assets of A, B, C, or D. Okay? This is an exception to Article 1816. If you remember 1816, a partner's liability is pro rata. That's why it had to be placed here. Okay. Now, let's go to paragraph 3. When a partnership is not liable, the partnership is in no case bound by any act of the partner after dissolution. Number 1, where the partnership is dissolved because it is unlawful to carry on the business, unless it is for winding up. So, obviously, if it's unlawful to carry on the business, say there was war, as I mentioned earlier, there was war between, say, China and the Philippines, and the partners are Chinese nationals and Filipino nationals. Therefore, the partnership is not bound even if, say, A enters into a partnership contract with another person, because the business is already declared illegal, assuming it was declared illegal, no? Number 2, where the partner has become insolvent, or 3, where the partner has no authority to wind up partnership affairs, except, meaning even if a partner has no authority to wind up partnership affairs, the partnership is still bound if if we are talking about a prior dealer, and we are talking about a third person who had no knowledge, no notice, and there was no advertisement. So, the A and B here is similar to A and B here. Okay? Nothing in this article shall affect the liability under Article 1825, Partnership by Estopel. So, someone who represents himself as a partner, even if it's dissolved, I'll give an example, no? If you remember example before, A, B, and C company is a company. Now, they were dissolved. Later on, they needed money. So, they asked D, can you help us get credit from X? Kasi A, we're not known people. You know, D, you're known in the business circle. Okay. So, D goes to X and says, hey, can you extend credit in my partnership here? I'm a partner of A, B, and C company. In that case, D is a partnership by Estopel because A, B, and C all agreed the partnership is liable, if you remember our discussion in the previous video. So, 1834 will not affect the liability of D as a partner by Estopel. Okay, before I move on to the next article, let me just clarify the effect of entering into a contract after the dissolution caused by an insolvency. Okay, kasi there are two provisions that will apply. Let me give an example. In a partnership between A, B, and C, called A, B, and C company, if A becomes insolvent, there are now different provisions will apply. Okay. Number 1, if C, as the acting partner, enters into a contract with X after A was already insolvent, two instances can apply. Number 1, if C knew that A was already insolvent and C continued to enter into a contract with X, B, being the innocent partner, is not liable. The partnership will not be liable also because C entered into that contract with X in bad faith. He already knew the partnership was dissolved. So the only authority he had was to wind up the affairs. He cannot enter into new contracts. Number 2, if C entered into a contract with X without knowing that A was already insolvent, so C entered into that contract with X in good faith, thinking everything was okay, then B, as the innocent partner, will still be liable. And that is under Article 1833, number 2. We just discussed that in the previous slide. Okay. Now, number 3, when will 1834 paragraph 3 number 2 apply? It will apply where A was already insolvent, so the partnership was dissolved, and then after, A entered into a contract with X, not C, A. A, as the insolvent partner, entered into a contract with X. In that case, the partnership is not bound under paragraph 3. Why? Because X is expected to know the financial status of the insolvent partner because he's contracting with the insolvent partner already. Not like in 1833 where X was transacting with C. C is not the insolvent partner, he's just the acting partner. Okay, so just take note of that. The general rule is the dissolution of the partnership does not of itself discharge the existing liability of any partner. But, there's a qualification, a partner is discharged from any existing liability upon the dissolution of the partnership by an agreement to that effect between himself, the partnership creditor, and the partner or the person or partnership continuing the business. And such agreement may be inferred from the course of dealing between the creditor having knowledge of the dissolution and the person or partnership continuing the business. Okay, what does it mean? It means that under paragraph 1, a partner who has withdrawn from the partnership is released from liability only when there has been a liquidation and his withdrawal has been published. That's in a Supreme Court case. So, again, a partner is released from liability only when there has been a liquidation already. The exception is if the partnership is continued. A partner is discharged from any existing liability if there is an agreement. But the agreement must be between the partner who wants to be absolved from liability, the partnership creditor, and the person or the partnership continuing the business. Please note that if you're talking about deceased partners, their liability is different. It will not follow also the general rule. The individual property of a deceased partner shall be liable for all obligations of the partnership incurred while he was a partner, but subject to the prior payment of his separate debts. Kasi 'di ba, a partner is liable for partnership liabilities if the partnership's assets are not enough and his liability is to the extent of his or her separate assets. But if you're talking about a deceased partner, it's the deceased partner's estate, the assets there, must first be subject to the prior payment of the deceased partner's personal debts. So if you look at 1839 number 8, just to cross-refer, no? When partnership property and the individual properties of the partners are in possession of a court for distribution, like estate, someone died, partnership creditors shall have priority on partnership property, and separate creditors shall have priority on individual property, saving the rights of lien or secured creditors. So, to wrap everything up when it comes to liabilities, how will the liabilities be satisfied? If you remember, I'm just sewing together the provisions that we just discussed. If the authority is terminated but the partnership is bound, the third person goes after the partnership assets first. If it's not enough, then the third person can go after the partner's separate assets because the partnership is bound. Other partners can go after the acting partner to recover what they have paid. Why can they recover? Because the authority of that acting partner has already been terminated. So, when you say the partnership is bound, an innocent partner cannot tell the third person, oh, you cannot run after my personal assets because the acting partner's authority has already ended. No. What the innocent partner must do is he or she must pay the third person and then seek reimbursement from the acting partner. Okay, number 2. If the authority is not terminated but the partnership is bound, then you act as if it's a normal partnership transaction. The third person goes after partnership assets. If it's not enough, the third person can go after the person's separate assets. The partners cannot seek reimbursement from each other. There's no recovery. They are liable as if there was no dissolution. Okay, number 3. If the acting partner's authority is terminated and the partnership is not bound, the partnership assets cannot be used to pay for that transaction. It is only the acting partner that is liable, as if it's a personal transaction between the acting partner and the third person. And number 4, if the authority is not terminated and the partnership is not bound, this was discussed by Soriano, not in the civil code. In cases where dissolution is caused by an act, death, or insolvency of the partner, and the acting partner had no knowledge, so the authority is not yet terminated, but the third person knew, then it will not bind the partnership or the acting partner, said Soriano. Why? Because the third person is in bad faith. You already knew that the partnership is dissolved. Number 2, you already knew, so, and you knew that the acting partner is innocent, had no idea that the partnership is already dissolved. Then the third party, okay, so now that we know when a partnership is considered dissolved, and now that we know the effects of a dissolution on the partner's liability and the partnership's liability, the question is, what do we have to do? Meaning, what do we do after declaring a dissolution? First, let's talk about who may wind up the business, because what we need to do is we need to wind up. Who may wind up the business? Under Article 1836, unless otherwise agreed, in the absence of any agreement, the partners who have not wrongfully dissolved the partnership or the legal representative of the last surviving partner, not insolvent, has the right to wind up the partnership affairs, provided, however, that any partner, his legal representative, or his assignee, upon cause shown, may obtain winding up by the court. When you say may obtain winding up by the court, when you go to court, you can actually have the court appoint another person to liquidate the affairs of the partnership. So this is in harmony with Article 1832, which said that all authority of any partner is terminated in so far as may be necessary to wind up partnership affairs. So this will narrow it down to say that not all partners, only those who have not wrongfully dissolved the partnership or the legal representative of the last surviving partner who is not insolvent. So I placed here an enumeration for easy reference. Number 1, if it's a judicial dissolution, the partner designated by the court, or I think pwede rin third person designated by a court. Number 2, if it's extrajudicial, it's the one designated by agreement, which is usually the managing partner. I put an asterisk here because there have already been several Supreme Court cases where the Supreme Court said it's the managing partner. But if you want to be strict with the 1836, it's the one designated by agreement. I'm just saying, for practicality purposes, usually the one designated by the agreement would be the managing partner. Number 3, otherwise, all partners who have not wrongfully dissolved the partnership. Or number 4, the legal representative of the last surviving partner who is not insolvent. So we are not referring to the legal representative of the deceased partner unless he was the last surviving partner. Okay, so how do we wind up the business? Meaning liquidation. Liquidation referring to reducing the property to cash and distributing the proceeds. So before I continue with this one, because this is actually very easy to understand, especially for accounting students like yourselves, there are exceptions to converting assets to cash, such as number 1, when there are no more debts, meaning the partnership need not pay anyone, and a division in kind, meaning a division of the property, may be fairly and equitably made. And number two, if the sale of the assets would be prejudicial to an innocent partner who has not consented to the sale. Let me give an example. Actually, there are three, but let me give an example to number two, where if the assets would be prejudicial to an innocent partner. In a U.S. case, Weisman versus Henkin, in that case, Weisman paid $2,250 to Henkin to form a partnership. It's actually a publication partnership. Si Henkin was an agent of publishers, and he was tasked to solicit subscriptions from different people. So, when he entered into a partnership, Henkin promised that he had no debts, but he did. So, when Weisman found out na, oh, wow, you lied to me, he wanted to dissolve the partnership. But if we dissolve the partnership and if you follow liquidation, which is the conversion of the assets to cash for the distribution, that would entail selling the equipment of that publishing partnership and 20,000 cards containing records of Henkin's business. So, in that case, the U.S. Supreme Court of Pennsylvania said that the sale, although it was actually considered prejudicial to Weisman. But that case, different yung nangyari because Weisman actually consented to the sale eh. Where that can be a case na there you can actually agree that you don't want to sell the assets because yun nga, in that case 20,000 records, I think it listed there sino yung mga partner, yung mga clients of Weisman eh. So if you sell that, then it's like it's like selling goodwill, diba? Something like that. Okay. And number three, an exception to the general rule where liquidation of the partnership would mean distributing the assets in kind and not just converting everything to cash, would be where a dissolution was based on a violation of agreement and a judicial sale of the assets would be tantamount to confiscation. So in these cases that I mentioned, the partners may agree in what proportion the partnership assets would be divided between them. So what would be an example of a judicial sale that would be tantamount to confiscation? There is a New York case cited by the book where I got these exemptions from, no? In that case, I really couldn't get the exact details. But in that case, for example, a partnership between A, B, and C, A was excluded from partnership affairs. So in that case, A wanted to dissolve the partnership because he was unjustifiably excluded. Now, what the Supreme Court did in that case was instead of dissolving it and selling the assets because it would be prejudicial to A, because A wouldn't know if the sale would be proper if B and C pocketed money to the exclusion of A. What the New York Supreme Court said was continue the business. Have A continue the business. Maybe so that A would have the resources to see the value of the partnership and the extent of damage caused by being excluded in the partnership affairs by B and C. So note what I mentioned when I cited the Supreme Court case was that it stated instances when liquidation is not necessary, particularly when there is an agreement as to what the parties shall receive. So this contemplates cases where the partnership is continued, and we will discuss that later. Though all partners have an implied authority to sell the partnership property and collect obligations due to the partnership, it is common and convenient to delegate these powers to one or more of the partners, who, as you remember in the kinds of partners, are called liquidating partners. Go to Article 1839. In settling accounts between the partners after the dissolution, the following rules shall be observed, subject to any agreement to the contrary, meaning they can agree otherwise. Number one, the assets of the partnership are the partnership property, Number 2, the contributions of the partners necessary for the payment of all liabilities specified in number 2. Okay. So, what are the liabilities of the partnership? And they are ranked in order of payment. Number 1, those owing to creditors other than partners. They must be paid first. Number 2, those owing to partners other than for capital or profits. Number 3, those owing to partners in respect of capital. And number 4, those owing to partners in respect of profits. So these assets shall be applied in the order of their declaration in number 1 of this article to the satisfaction of the liabilities. Okay. Now, what if there are no profits? There's a loss. The partner shall contribute as provided by Article 1797 the amount necessary to satisfy the liabilities. So that deficit in that case, if you will be called a capital loss, which I'm sure you're very familiar with. So even this will also include a contribution by the estate of the deceased partner. So if any of the partners do not pay, if any does not pay their respective share of the loss, the other partners still have to pay, but they can sue the non-paying partner for damages. Okay, number 5, an assignee for the benefit of the creditors or any person appointed by the court shall have the right to enforce the contribution specified in the preceding number. Number 6, any partner or his legal representative shall have the right to enforce the contribution specified in number 4 to the extent of the amount which he had paid in excess of his share of the liability. That's self-explanatory. Number 7, the individual property of a deceased partner shall be liable for the contribution specified in number 4. That's what I've said. Meaning, even the estate of the deceased partner would be made liable to pay, to shoulder the capital loss. Number 8, when partnership property and the individual properties of the partners are in possession of a court for distribution, the partnership creditor shall have priority on partnership property and the separate creditors shall have priority on individual property, saving the rights of lien or secured creditors. And number 9, where a partner has become insolvent or his estate is insolvent, the claims against his separate property shall rank in the following order: those owing to separate creditors, those owing to partnership creditors, and those owing to partners by way of contribution. Why is this necessary? Because number 4, number 5, number 6, and number 7 already stated that each partner must contribute their share in the capital loss. The exception would be if a partner is insolvent or the estate is insolvent. Because in case of insolvency, there is priority to the insolvent partner's separate creditors first, before the partnership creditors, and before they give their contribution. Okay, so let me give an example. Because it was a bit long, although it is easy, if you've noticed. Yeah, so I hope you're familiar with Powerpuff Girls. So this is Bubbles, Blossom, and Buttercup. So let's give an example. Bubbles contributed 15,000, Blossom 10,000, and Buttercup 5,000. In scenario A, if the assets of the partnership Powerpuff Girls, if the assets of Powerpuff Girls are 50,000, and the Powerpuff Girls liabilities is 7,000 to D, 5,000 to E, and 2,000 to Bubbles, meaning aside from the 15,000 capital contribution. The solution would be first, the assets, 50,000, would be used to satisfy first D and E, 7 and 5,000. If there's enough, then to Bubbles as payment for her loan, say, not capital contribution. So there will be a remaining 36,000. Then you deduct the equity, meaning the contributions of the 3 girls. Then there will be a 6,000 net income. Now, if there is an agreement as to the profit sharing, then that agreement will be followed. Otherwise, if you remember our previous discussion, it will be according to the capital contribution of the partners. So it will be 3,600 for Bubbles, 2,000 or 1,600 to 2,600 to Blossom, and 1,000 pesos or 1,600 to Buttercup in addition to their capital contribution. Okay, that's fairly easy, right? Okay, that's scenario A. What about scenario B? There are more liabilities than there are assets. So there will be a 6,000 loss and it will be shared by agreement or in the absence of agreement according to their capital contribution. So the losses will be shared, 3,000 loss to Bubbles, 2,000 loss to Blossom, and 1,000 loss to Buttercup. Kasi you're using the same percentages. Okay. Scenario C. Same as scenario A, where there are assets of 50, liabilities of 7,000 to D, 5,000 to E, and 2,000 to Bubbles. But Buttercup owes F 4,000 pesos, meaning Buttercup has a personal, separate liability to another person outside of the Powerpuff partnership. Here, F can get Buttercup's 1,000 share in the profit. The remaining 3,000 she owes F will be from Buttercup's individual property. Okay, why did I arrive at that conclusion? If I may refer here to scenario A, because there is a net profit, then Buttercup will receive 1,000 net profit. So F can get the 1,000 share in the profit. The remaining 3,000 she owes F will be from Buttercup's individual property, which includes the 5,000 already. That will be her individual property anyway. Okay. And scenario D. Same facts. 50,000 assets, liabilities to D, to E, to Bubbles, but Buttercup owes F 4,000 and her personal assets are only 4,500. So F shall first be paid the 4,000 out of personal assets because she owes F. So F as the personal creditor will run after Buttercup's personal assets. And then the remaining, 500 yan. The remaining 500 shall be Buttercup's additional contribution, assuming that there is a loss. Let's assume here that there is a capital loss. If there is a capital loss, how do I go about this? Let's say if for example, the total loss is 56,000. Aside, this is including the liabilities already. Yan. Sorry, that did not make sense. So please do note. If you have any questions, please feel free to message me. I hope I did not confuse anyone. Before I move on, if in scenario B, so they will be sharing in the capital loss. If, for example, Blossom paid the entire 6,000 additional contribution, she can now recover 3,000 from Bubbles and 1,000 from Buttercup because of the sharing. So, Blossom's estate will still be liable if, for example, she passed away, as long as the 56,000 liabilities were incurred while she was still a partner. So I just discussed two additional scenarios. One, if B was the one who shouldered for the entire capital loss, she can recover from Bubbles and Buttercup their respective shares. And number two, if Blossom passes away, Blossom's estate will still be liable for her share. And how much would that be? 2,000. As long as the entire 56,000 liability was incurred while she was still alive. She was still a partner. Okay. So, in discussing dissolution and liquidation, we have mentioned some rights that either any or some partners have. To recap, we have already mentioned 1, the authority of the partners to cause the dissolution under 1830, 1831, 1840, and 1838. Number 2, the power of any partner to wind up partnership affairs or to complete transactions, unfinished transactions. Number 3, a partner's right to his or her share in the profits in surplus under 1816. Number 4, a partner or his or her legal representative or assignee's right to enforce contributions against their co-partners in the event of a capital loss. And number 5, 1842. The right to an account of his interests shall accrue to any partner or his legal representative against the winding up partners or surviving partners or the person or partnership continuing the business at the date of dissolution in the absence of any agreement to the contrary. So number 5 is the right to a formal accounting. So here, there can be an agreement delaying this right to a formal accounting at a later date. The person liable to render an account are, as we've mentioned, a liquidating partner, a surviving partner, or a person or partnership continuing the business. So when you say person, it can be a continuing partner or a third person added to the partnership. So why is this provision important? Because under the law, an entity's right is not, or a person's right is not eternal. We have what we call a prescriptive period. So it depends on the source of obligation. If you remember your oblicon, the sources of obligation are law, contracts, quasi-contracts, delicts, quasi-delicts. So if the prescriptive period for a right has lapsed, a person cannot seek the enforcement of the right. So what does that have to do in this case? In this case, we're talking about the right to a formal accounting. So the prescriptive period here is usually 4 years. Now, if you look at 1842, it says, the right shall accrue at the date of dissolution. So you'd think, okay, so if the partnership was dissolved on January 1, 2020, then the right for a formal accounting prescribes in January, or rather December 31, 2023. Tama ba? O diba? You might think na, okay, then the right has prescribed by then because 4 years have lapsed. Take note, there is a Supreme Court case which stated that when you apply 1842 in its relation to when a partner may ask for an accounting, for as long as the partnership exists, any of the partners may demand an accounting. So the prescription of the said period or the said right starts to run upon the dissolution of the partnership when the final accounting is done. So what if the partnership is dissolved because A died in January 1, 2020, but the formal accounting was done in November 2020? Then the prescriptive period of 4 years starts from November, not January. Otherwise, it would be unfair. So when a final accounting is made, it is only then that prescription begins to run. Okay, now we move to the 6th right. When the dissolution is caused in any way except in contravention of the partnership agreement, each partner as against his co-partners and all persons claiming through them, unless otherwise agreed, may have the partnership property applied to discharge partnership liabilities, and the surplus applied to pay in cash net amount owing to the respective partners. So if the dissolution is caused by a partner bona fide under agreement, and if the expelled partner is discharged from all liabilities, either by payment or agreement under 1835 when agreed by the, if you remember, if it was agreed by the partner who was supposed to be, if the partner was by the expelled partner, creditor, and the continuing partner or partnership, he shall receive in cash only the net amount due him from the partnership. So it's not the entire surplus. In cases of expulsion of a partner, bona fide under agreement. So, again, when we say bona fide, it means expulsion of a partner without violating the partnership agreement. Okay. So, the first right, under the sixth right, no? The first paragraph states that a partner has a right to have the partnership property applied to liabilities and the surplus paid in cash, net of the capital contribution. If it's an expulsion of a partner, that expelled partner's right is, if he is discharged from liability, can be to receive cash net of the amount due him from the partnership. Okay, number 2. When the dissolution is caused in violation of the agreement, then the rights of the partners are as follows. Number 1, for the innocent partners, all the rights in number 1, meaning to have it applied, to receive the surplus in cash. In letter B, the right as against the wrongful partner to damages for breach of the agreement. Number 2, the innocent partners, if they want to continue the business, may do so. And they may do so during the agreed terms of partnership, and for that purpose, they may possess partnership property provided, meaning they can continue the business and use partnership property only if either they pay a bond approved by the court or they pay the guilty partner the value of his interest at dissolution. But when they pay him, the guilty partner, so that they can continue with the new business, they first have to pay, they can remove damages that they can recover from that guilty partner, and less any damages recoverable under paragraph 1B. And then they may indemnify him against all present or future partnership liabilities. Okay, number 3, a partner what happens and what are the rights of the guilty partner? If the business is not continued, he has the rights, meaning he can demand for the surplus and to be paid in cash, but his share will be deducted for liability for damages. And the guilty partner's right, if the partnership is continued, he will have the right to have the value of his interest in the partnership, less any damages he caused. And it can be paid in cash or, as I've mentioned, through a bond approved by the court. And then afterwards, he will be released from all existing liabilities because this is a case where the partnership will be continued. Okay, so if you are the guilty partner, sorry, not you, if one is a guilty partner, the value of that guilty partner's interest will not include goodwill. Because usually, diba, goodwill is a significant amount when they value it. If I may summarize, again, because this is a long provision, if the dissolution is in contravention of the agreement, here, this paragraph, the one from here below, the partner's rights would depend on whether or not they are innocent or guilty. If the partner is innocent, they have the right to have the partnership property applied for the payment of partnership liabilities and receive his share of the surplus in cash. 2, that innocent partner has the right to be indemnified for damages caused by the guilty partner for the wrongful dissolution. Number 3, that innocent partner has the right to continue the business in the same name during the agreed term, meaning to finish the term agreed upon, either by themselves, silang innocent partners, or jointly with a third person. And number 4, if they continue the business, the innocent partners, as the one who are continuing the business, have the right to possess partnership property if they decide to continue. But in continuing the business, the innocent partner's right is conditioned by obtaining a bond or paying first the guilty party the value of his interest less damages, because you're going to just continue the use of the partnership property. So in that case, you have to discharge the guilty party of all existing and future liabilities because that will be absorbed by the continuing partners and the new partnership. Okay. And again, to summarize, what are the rights naman of the guilty partner? No, if the business is completely terminated, he has the same rights as an innocent partner except that he must pay damages. And number two, if the business is continued, he has the right to have his share valued, excluding goodwill, and that can be paid to him in cash or through court-approved bonds, less damages. And he has the right to be discharged from all existing and future liabilities. So in effect, that there is a case of the purchase of the guilty partner's share. That's what happens when you continue the business. It's like the innocent partners are purchasing the guilty partner's share in the business, less the damages. Okay. Okay. So, the question is, it's not over? So, no, it's not. Since partners are free to enter into any contract as long as it's not contrary to law, morals, good customs, public order, or public policy, the partners may opt to continue the business. Strictly speaking, it is really the creation of a new partnership using the old partnership's property. The Civil Code, however, provides for rules when continuing a partnership to protect certain persons, which we will discuss later on, and to make the transition from the old to the new partnership smooth. That's why there are certain provisions for that. Okay. So here, we're talking about the rights of old creditors. So in cases like this, the dissolution of the old partnership is called a technical dissolution. Okay. So this is from Catch Me If You Can. So what are the rights of old creditors? Under Article 1840, in the following cases, creditors of the dissolved partnership are also creditors of the new partnership. I'll just say new partnership for easy reference. No? Number one, when any new partner is admitted into an existing partnership, or when any partner retires and assigns his rights in partnership property to two or more partners, or to continuing partners or third persons, if the business is continued without liquidation of the partnership affairs. Yeah. If the business is continued without the liquidation of the partnership affairs, then the creditors of the old partnership will be creditors of the new one. Excuse me. Number two, when all but one partner retire and assign their rights in partnership property to the remaining partner, who continues the business without liquidation, either alone or with others. Number three, when any partner retires or dies and the business of the dissolved partnership is continued with the consent of the retired partners or the representative of the deceased partner, but without assignment of his right. Number four, when all the partners or the representatives assign their rights in the partnership to one or more persons who promise to pay the debts and continue the business of the dissolved partnership. So here, obviously, the old creditors will be the creditors of the new partnership because these people promise that they will absorb the liability of the old partnership. Number five, when any partner wrongfully causes the dissolution and the remaining partners continue the business under the provisions of 1837, either alone or with others and without liquidation of the partnership affairs. So 1837, if you remember, it's what I just mentioned a while ago about continuing the business. Just the previous slide. Okay. And number six, when a partner is expelled and the remaining partners continue the business, either alone or with others, without the liquidation of partnership affairs. The liability of a third person becoming a partner in the new partnership shall be satisfied out of the partnership property only unless there is a stipulation to the contrary. So when the business of a partnership after dissolution is continued, as against the separate creditors of the retiring or deceased partner, they have a prior right to any claim of the retired partner or the representative of the deceased partner against the new partnership. And nothing in this article shall be held to modify any right of creditors to set aside any assignment on the ground of fraud. So, it means that if the assignment is on the ground of fraud, then the creditors shall be liable, shall have the same rights to the new partnership. And the new partnership cannot say, oh, we're not liable to you because you do not fall under any of these circumstances. Okay. The use by the person or by the new partner of the partnership name or the name of the deceased partner as part thereof shall not itself make the deceased partner liable for debts contracted by such person. Okay, so 1840 shows that both classes of creditors, the creditors of the old partnership and the creditors of the new partnership, are treated alike and are given equal rights in partnership property. This is in order to maintain the preferential rights of old creditors to the partnership property as against the partner's separate creditors. So if you remember, a partner's personal creditors, separate creditors, can run after partnership property by assignment. We have discussed that in week 2. That's why there's a need for 1840. Now, if you note in number 4, here, when third persons promise to pay the debts, if the third person's continuing the business, meaning a new business composed of completely different people, if they do not promise to pay the debts of the dissolved partnership, the old creditors will have no claim on the new partnership. However, this is not absolute because if you can see, it will not modify any rights of an old creditor if the assignment to a third person was made based on fraud. Now, before we move on, let me just explain that here, the use of the new partnership, the use of the old partnership name by the new partnership will not make the deceased or retired partner liable for debts contracted. Why is there a need for this provision? It's quite obvious. No? The reason for this last paragraph is that without this provision, Article 1815 would apply. If you remember 1815, it said that those who, not being members of the partnership, include their names in the firm name shall be subject to the liability of a partner. So the exception to 1815 is here. If a deceased or retired partner allows his name to be used in the new partnership, he will not be liable. Continuing despite death. Under Article 1841, when any partner retires or dies and the business is continued under any of the conditions set forth in the preceding article, or in Article 1837, if you remember, the 1837 refers to the rights of the guilty and innocent partners. If the innocent partners continue the partnership, okay. So when any partner retires or dies and the business is continued without any settlement of accounts as between him or the estate and the new business, unless otherwise agreed, this retired partner or the representative of the deceased partner may have the value of his interest at the date of the dissolution ascertained. And that partner shall receive as an ordinary creditor an amount equal to the value of his interest in the dissolved partnership with interest, or at his option or at the option of the representative, instead of getting interest, the partner can get profits attributable to the use of his right in the property of the dissolved partnership. So, provided that the creditors of the dissolved partnership as against the separate creditors or the representatives of the retired or deceased partner shall have priority claim on any claim arising under this article as provided under Article 1840, third paragraph. So, Note that no specific amount or property may be adjudicated to the heirs of the deceased partner without the liquidation of the partnership being first terminated. The partners may even provide for an agreement regarding liquidation of the partnership upon death of one or any of its partners, and the deceased partner's representative has no rights outside that agreement. So there is also no liquidation necessary when there is also a settlement or agreement as to what a retiring partner shall receive. The acceptance of such payment by the retiring partner will preclude him from later on claiming their supposed share in the profits at the time of dissolution. That's what it meant by unless otherwise agreed. So again, I'll repeat under Article 1841, the partnership can be continued despite the death of a partner. In that case, that the retiring partner or the representative of the deceased partner has the right to have the value of his interest ascertained, and he shall receive as an ordinary creditor, not just as a partner, as an ordinary creditor, the amount equal to the value of his interest in the dissolved partnership, with interest pa. If they don't want to be paid interest for their share, they can ask that instead of interest, they be paid profits. There. So, that ends this video, and I will see you again when we talk about limited partnership.